Hello everyone. In this video, we will be discussing the crimes of murder and homicide, and we will also touch on the crimes of infanticide and parricide. It is essential that you familiarize yourselves with these crimes. These are some of the important crimes which you will encounter in Book 2 of the Revised Penal Code. I suggest you just sit down, relax, and listen, and I guarantee you that after watching this video, you will have gained enough knowledge to answer the basic questions surrounding these crimes. So let's start. Sa video na ito, we will learn the basic principles underlying the different crimes. We will study also their elements, and then we will try to answer these questions. What is the crime committed if 1. Stabbed Pedro in the stomach with a knife and Pedro died? Or what if he stabbed Pedro while sleeping and Pedro died? Or what if he stabbed Pedro in the stomach with a knife with the intention of killing him, pero hindi namatay si Pedro? Or, what if he stabbed Pedro in the stomach with a knife pero wala siyang intent to kill, tapos hindi naman namatay si Pedro? So, anong mga crimes na nakumit dito? Or, what is the crime committed if 1 killed his live-in partner or yung ka-live-in niya? Or, paano kung pinatay niya yung kanyang 2-day-old child? Or yung kanyang adopted child? Or, how about when 1 killed his daughter? What crime is committed by 1? So, malalaman natin yung mga kasagutan dito. And also, what is the crime committed if Pedro burned the house of 1, not knowing that 1 was inside and 1 died as a consequence? So, hindi niya alam na nandun sa loob si 1 at namatay si 1. So, anong crime na nakumit ni Pedro dito? Or, what is the crime committed if Pedro wanted to kill 1 and upon knowing that 1 was inside his house, Pedro burned the house and 1 died? Or what is the crime committed if Pedro killed 1 and to dispose of the corpse, he burned the house of 1 along with the corpse? So take note that there are different facts in these 3 questions. Each question is different from the others. So you have to analyze the facts carefully. Susubukan nating sagutin ang mga questions na to as we go on in our discussion. The crimes of murder and homicide fall under Title 8, which is crimes against person. Now, these are the articles defining the crimes of homicide and murder, and these are the respective elements of these crimes. The main difference and the fundamental distinction between the crime of homicide and the crime of murder is the presence of a qualifying circumstance. Take note that in homicide, it must not be attended by a qualifying circumstance, which is not the case when it comes to the crime of murder, because qualifying circumstance is one of the elements of the crime. Now, in Article 248, defining the crime of murder, you can see there 6 sub-paragraphs which enumerate the qualifying circumstances. Now, if you look closely, they are very familiar because you can find them under Aggravating Circumstances, Article 14. Now, these are the aggravating circumstances, and the highlighted numbers are those which can be found under Article 248. Now, all of these can be found under Article 14 except outraging or scoffing at his person or corpse. You cannot find this under Article 14. There are 4 kinds of aggravating circumstances under Article 14. We have generic, specific, qualifying, and inherent. Now, generic aggravating circumstances are those that generally apply to all crimes. An example of this would be recidivism. Now, if you study recidivism under Article 14, you are a recidivist if, at the time of your trial for one crime, you shall have been previously convicted by final judgment of a crime falling under the same title. So if you committed the crime of parricide and then homicide, then they fall under the same title, which is Title 8, Crimes Against Person. Then we have specific aggravating circumstances, those that apply only to particular crimes. An example of this would be treachery. In treachery, it only applies to crimes against person. Then we have qualifying aggravating circumstances, those that change the nature of the crime. An example of this would be relationship. So in the crime of seduction, relationship qualifies the crime to qualified seduction. Inherent aggravating circumstances, those that necessarily accompany the commission of the crime. An example of this would be evident premeditation. It has been declared that in crimes like theft, robbery, estafa, adultery, or concubinage, evident premeditation necessarily accompanies the commission of these crimes. Now let's concentrate on qualifying aggravating circumstances. Qualifying aggravating circumstances affect the nature of the crime, such that the offenders shall be liable for a more serious crime. So in the unlawful killing of a person, if it is attended by a qualifying circumstance, then it would change the nature of the crime to murder. And these circumstances are actually an ingredient of the crime. So if you take a look at the elements of murder, we can see that qualifying circumstance is one of the elements of the crime of murder. Let us now discuss the crime of murder. Now, there are 4 elements of murder. The first element is that a person was killed. It is necessary that there be a deceased person. When we say that a person was killed, we are talking about a consummated crime of murder. Now, under Article 6, a felony is consummated when all the elements necessary for its execution and accomplishment are present. The second element is that the accused killed him. Now, take note that there are 3 kinds of principles. We have principle by direct participation, the principle by inducement, and the principle by indispensable cooperation. Now, the third element is that the killing was attended by any of the qualifying circumstances under Article 248. And let's discuss them one by one. Treachery, as I mentioned earlier, applies to crimes against person, and murder is a crime against person. Now, treachery exists when the offender employs means, methods, or forms which tend directly or specially to ensure the commission of the crime without any risk arising from the defense which the offended party might make. So in other words dito, parang yung pinatraidor or inattack yung offended party ng walang kamalay-malay or patalikod, taking advantage of superior strength. In one case, nung sinaksak nung lalaki yung babae, the court declared that his sex and his weapon afforded him superiority in strength. With aid of armed men. So, humingi ka ng tulong ng mga armadong mga tao, employing means to weaken the defense. So, an example of this would be when 2 persons are fighting each other and yung isa tinapunan ng buhangin yung mata. Of means or persons to ensure or afford impunity. An example of this would be using mask or something to cover your face. In that way, you are preventing the offended party or any witnesses from recognizing you. And take note of this rule. Pag merong treachery, merong taking advantage of superior strength, and merong with aid of armed men, you only consider one to qualify the killing of the person to murder, and the others will be considered absorbed by treachery. Pero kapag merong treachery, merong consideration of a price, reward, or promise, at meron ding, for example, evident premeditation, you only consider one for the purpose of qualifying the crime to murder. The other 2 will be considered generic aggravating circumstances. Next, in consideration of a price, reward, or promise. So dito, merong dalawang principles. The principle by inducement and principle by direct participation. Yung principle by inducement, siya yung nag-offer ng reward, promise, or price. Yung principle by direct participation, siya yung hitman. Siya yung nag-pull ng trigger. Sa number 3, the important words that you have to take note of are by means of. Ang ibig sabihin ng by means of, the offender consciously adopted the use of these means or method to kill a person. In other words, at the onset, there's a design to kill. There's an actual design to kill. His intention is really to kill the person. That's why he used these means or methods. Like for example, fire. Kung susunugin niya yung tao, then that's murder. Now, let us try to answer these questions involving the use of fire and also involving the death of a person. So, what are the possible crimes committed? So, in this first question, what is the crime committed if Pedro burned the house of Juan, not knowing that Juan was inside, and Juan died as a consequence? So, sinunog ni Pedro yung bahay ni Juan, pero hindi niya naman alam na meron si Juan sa loob. So, ang gusto niya lang is sunugin yung bahay. Hindi niya intensyon na pumatay ng tao. So what is the crime committed here? The crime committed is simply arson, and the resulting homicide is absorbed. So since sinunog niya lang yung bahay ni Juan at hindi niya naman intensyon talaga na masunog si Juan at mamatay si Juan, arson lang ang nakumit niya. Yung homicide, ma-absorb na ng arson. Now next question, what is the crime committed if Pedro wanted to kill Juan, and upon knowing that Juan was inside his house, Pedro burned the house and Juan died? So sa question naman to, alam niya na nandoon sa loob si Juan at meron siyang intent to kill. Gusto niyang patayin si Juan, kaya ang ginawa niya, sinunog niya yung bahay para masunog rin si Juan at mamatay. Now what is the crime committed here by Pedro? Now the crime is murder by means of fire under Article 248. Now here there's an intention to kill and there's conscious adoption of the use of fire to take the life of one. Now, what if Pedro killed Juan and to dispose of the corpse, he burned the house of Juan along with the corpse? So in order to cover up the crime, yung pagpatay niya kay Juan, sinunog niya yung bahay. Siguro para masunog rin yung bangkay. Now, what is the crime committed by Pedro here? Or what are the crimes committed by Pedro? The crimes are homicide or murder, depending on the manner of execution of the killing of Juan, kung paano niya pinatay si Juan. Kung walang qualifying circumstances, it's homicide. Kung merong qualifying circumstances, it's murder. And arson. So there are two crimes here. Pag pinatay niya si Juan, and then sinunog niya yung bahay, para i-cover up yung crime na nakumit niya sa pagpatay kay Juan, then that is also arson. So the crimes committed are homicide or murder and arson. So ito ang difference ng tatlong questions na to involving three different cases, no? At ang basis dito is jurisprudence. So you have to read the case of People versus Baluntong, GR number 182061, March 15, 2010. So again, I repeat, dito sa number 3, kailangang may intent to kill. Kasi nga, the offender consciously adopted the use of these means to kill a person. Then we have on occasion of any of these public calamities. You have to remember that it's not only because of the existence of these public calamities. Hindi lang dahil sa mayroong public calamities, kundi the offender must have taken advantage of these public calamities with evident premeditation. Sa evident premeditation, the offender must have had a time to coolly reflect on his actions. There are three requisites here that must be complied. First is the time when the offender determined to commit the act or to commit the crime. Second is the act manifestly indicating that he clung to his determination. And then third is the sufficient lapse of time between the execution and the determination. And then number 6 with cruelty. Sa cruelty, there is an intention to inflict unnecessary pain. For example, bago mo siya pinatay, tinorture mo pa siya or pinagsasaksak mo ng 100 times bago siya namatay. Those are unnecessary ways to kill a person. And then outraging or scoffing at his person or corpse. For example, namatay na, tapos pinugutan mo pa ng ulo. Now that's an example of outraging or scoffing at his corpse. You should also know that the killing of a child is murder. The killing of a child of tender years is considered murder because a child is defenseless. A child is unable to put up a defense and to parry your attacks. That's why the law presumes or assumes the existence of the qualifying circumstance of treachery in the killing of a child. Do you need to prove intent to kill in murder? Kailangan ba ng intent to kill? The answer is no. The law merely requires the voluntary presence of the qualifying circumstance. So kapag namatay yung tao, and then merong qualifying circumstance, then the crime will be qualified to murder. Take note of Article 4. I will make a separate video discussing Article 4. Ito kasing Article 4 sa criminal liability, although hindi mo intention na pumatay, the fact na namatay, you shall be liable for the material result of the crime by any person committing a felony, although the wrongful act done be different from that which he intended. So, we have a case here. For example, hypothetical scenario lang. Juan held a grudge against Pedro. So, while Pedro was walking on the street, Juan shouted at him, "Babasagin ko mukha mo," and punched him in the face. Pedro fell down and hit his head on the pavement. Because of the impact, Pedro died. Is Juan criminally liable? Now, let's look at the facts. Dito, sinabihan niya na babasagin ko mukha mo. So there is no intent to kill. Only na manakit lang. Pero nung sinuntok niya, nahulog, namatay si Pedro. So iba yung intention niya sa kinalabasan ng kanyang act. Is Juan criminally liable? So in other words, dito, walang intention to kill. Is Juan still criminally liable even though there is no intent to kill? The answer is Juan is liable for the death of Pedro even if there is no intent to kill because of Article 4. Intent to kill is not necessary in paragraphs 1, 2, 4, 5, and 6. In murder. However, intent to kill is necessary in paragraph 3. Remember yung sinabi natin kanina, you have take note of the words by means of. It means that the offender consciously adopted the use of these methods, ways to kill a person. It means na from the very beginning, there is an actual design to kill. Kaya nga niya ginamit to para pumatay. So dito sa number 3, kailangang may intent to kill talaga. So, intent to kill is not necessary in 1, 2, 4, 5, and 6, except number 3. Example, while Pedro was talking to his father in the sidewalk, Juan approached Pedro from behind and gave him a fist blow at the back part of Pedro's head and ran away. Pedro suffered a mortal wound which caused his death. Is Juan liable for the crime of murder even if there is no intent to kill? So dito, inatake niya si Pedro nung nakatalikod si Pedro. The possible qualifying circumstance here is treachery. Yes, one is liable for the direct, natural, and logical consequence. Because there is treachery in the manner of execution, the crime is qualified to murder. So kahit na walang intent to kill dito, kasi 'di ba sinuntok niya lang, walang intent to kill, liable pa rin siya for murder because of the presence of treachery. How about in this example? One wanted to arouse Maria sexually, so he gave her a chocolate mixed with catharide. Because catharide contained poison, Maria died. Is one liable for the crime of murder? So eto, may intent to kill ba dito? Wala. Ang intention lang ni Juan is to arouse Maria sexually. Pero nagkataon lang na may na-poison pala ang catharide, kaya namatay si Maria. So walang intent to kill, pero namatay si Maria. Is one liable for the crime of murder? The answer is no, because Juan has no intent to kill the victim, and he did not use poison to kill her, but only to arouse her sexually. Just remember yung sinabi natin kanina, di ba? Intent to kill is not necessary sa 1 to 6, except number 3. Kasi nga, by means of, there is an actual intent to kill. Kaya niya ginamit ang fire, poison, explosion. So talagang meron siyang intention to kill sa number 3. Unlike sa 1, 2, 4, 5, 6, kailangan lang present sila. Pero sa number 3, kailangan may intent to kill talaga. Then 1 is only liable for homicide. Kasi namatay si Maria, although hindi murder, liable pa rin siya sa pagkamatay niya. So, the crime would be homicide. Now, the fourth element in the crime of murder is that the killing is not parricide or infanticide. What is parricide? Any person who shall kill his, so these are the offended parties, father or mother, child, legitimate or illegitimate, legitimate other ascendant or descendant, and then legitimate spouse. Dito sa child, he can either be legitimate or illegitimate. Pag sinabi mong illegitimate, yan yung anak ng dalawang tao na hindi kasal. Eto sa number 3, kailangan yung other ascendant at saka descendant is legitimate. Now let's take a look at this diagram to really understand the crime of parricide. One is the father and Maria is the mother, but they are not married and they have a son, Pedro. The status of their son is illegitimate because Juan and Maria are not married. Now, if Pedro has a son, it can either be legitimate or illegitimate, depending on whether Pedro was married during that time. If Pedro kills his son, whether his son is legitimate or illegitimate, it would fall under parricide. That is not the case with respect to Juan and Maria. If Juan kills Pedro Jr., it will not fall under parricide because the relationship is illegitimate. Remember that their son is illegitimate. And if Maria would kill Pedro Jr., since the relationship is illegitimate, it will not fall under parricide because under parricide, the law requires that the relationship with the other ascendant or the other descendant must be legitimate. And another case, if one kills Maria, it will also not fall under parricide because the law requires that the spouse must be legitimate. And in order to be legitimate, both of them must be married. But in this case, they are not married. So if Maria kills one or one kills Maria, it will not fall under parricide. Then we have the spouse who must be legitimate. Pag sinabi mong legitimate, kasal sila. There's a benefit of marriage. Merong marital union. Kapag sinabi mong live-in partner or common law wife, hindi legitimate ang relationship. So kapag pinatay mo ang live-in partner mo or ang common law wife mo, hindi siya magiging parricide. The killing is not parricide or infanticide. Now, eto naman sa infanticide, any person who shall kill any child less than 3 days of age. So here are the elements: that a child was killed, the deceased child was less than 3 days, the accused killed the child. So the important words here to remember are less than. Ito, less than. Ibig sabihin, hindi 3 days. Mas mababa sa 3 days. Pag 3 days siya, it can be parricide, homicide, or murder. Kailangan less than 3 days. Questions here para masubok natin kung talagang naintindihan natin. No? What is the crime committed when one killed his live-in partner Maria? Of course, the relationship is not legitimate, so it's not parricide, homicide, or murder. 2-day-old child, syempre, diba? Infanticide. 7-year-old adopted child. Now, dito sa adopted child, hindi mo siya kadugo, but he is considered your child because of fiction of law. Sa parricide kasi, ang common denominator nila is relationship by blood, except sa spouse. Since hindi by blood itong sa adopted child, hindi siya magiging parricide. So the crime is murder. At saka bakit murder? Kasi tingnan niyo yung age, 7-year-old, na pag-aralan natin kanina na the killing of a child of tender years is always murder because of treachery. Ang child is considered as defenseless. Then how about the daughter? One killed his daughter. Parricide. Let us now study the crime of homicide. Homicide under Article 249. Now these are the elements of the crime of homicide. The first is that a person was killed. Again, we are talking of a consummated crime of homicide. Now in all crimes against persons in which the death of the victim is an element of the offense, there must be satisfactory evidence of corpus delicti or body of the crime. It does not refer to the corpse or the body of the deceased person. Corpus delicti means that the crime has been committed or breach or violation of a law or the fact of commission of a crime. And then, number 2, we have the identity of the victim. There is no justifying circumstance under Article 11. Justifying circumstances are those where the act of a person is said to be in accordance with law. Siyempre, pag mayroong justifying circumstance, yung pagpatay sa tao, it is considered as justified. Since it is justified, there is no criminal and civil liability, except paragraph 4. Yung state of necessity. So these are now the justifying circumstances under Article 11. And para mas madaling ma-memorize, ito yun sila. Self-defense, defense of relatives, etc. The third element of homicide is that there is an intention to kill, which is presumed. Now, do you need to prove intent to kill in homicide? Intent to kill is conclusively presumed when death resulted. So, kapag namatay ang isang tao, hindi mo na kailangang alamin kung merong intent to kill. Kasi, in the eyes of the law, there is intent to kill because intent to kill is conclusively presumed when death resulted. Kasi ang tinitignan ng law is yung material result, ano ang kinalabasan. And the aggressor shall be responsible for all the consequences thereof. And remember Article 4. Now, kung totoo man na walang intent to kill, then his liability will only be mitigated under Article 13, subparagraph 3, no, or praeter intentionem, that he had no intention to commit so grave a wrong as that committed. Meron lang mitigating circumstance, pero ang liability niya is still for the crime of homicide. Now, when is intent to kill important? When the victim did not die. Pag hindi namatay ang victim, you need to know if there is an intent to kill. Kasi if there is an intent to kill, the possible crimes committed are frustrated and attempted homicide. And if there is no intent to kill, the possible crime committed is physical injury. Now we have an example here. Pedro wanted to kill Juan, so he waited for him in the corner where Juan usually passed by. When he saw Juan, he shot him with a gun. Because of poor aim, he missed Juan and the bullet landed on a bystander who died as a consequence. Now, what crime or crimes were committed? Now, let's analyze the case now. Pedro wanted to kill Juan, so may intent to kill. Gusto niyang patayin si Juan. Nung binaril niya, because of poor aim, hindi niya tinamaan si Juan. Sa halip, ang natamaan niya is yung bystander na namatay. So, what are the crimes committed? Sa bystander and kay Juan. Sa bystander, namatay ba? Namatay, diba? So, the law conclusively presumes that there's an intent to kill. So, ang crime dito is homicide. Kay Juan, namatay ba si Juan? Hindi, di ba? Pero may intent to kill. So, attempted homicide. Let's discuss another example here. Pedro wanted to kill Juan, so he waited for him in the corner. So, same pa rin, no? Same sa number 1, except the bystander who was hospitalized for more than 30 days. So, sa second example, hindi namatay. Na-hospital lang siya for more than 30 days. So, what crimes were committed? So, kay Juan, ganun pa rin. Attempted homicide pa rin kasi may intent to kill. Now, how about sa bystander? Namatay ba? So, hindi. So, kailangan nating alamin kung may intent to kill o wala. May intent to kill ba sa bystander? Siyempre, wala. Nadamay lang siya, diba? Since hindi namatay at walang intent to kill, ang crime na nakumit sa bystander is only for serious physical injury. So, that's how you apply intent to kill in the crime of homicide. And then, the fourth element is that it must not be attended by a qualifying circumstance. Kasi, pag meron ng qualifying circumstance, the crime, the killing of the person or the unlawful killing of the person will now be elevated to murder. Then, the fifth element, we have it must not be parricide or infanticide. So, we have already discussed this. Just take note now of the difference between homicide and murder with respect to penalty. Sa homicide, reclusion temporal. Sa murder, we have reclusion temporal in its maximum period to death. But take note of RA Republic Act 9346, which abolished death penalty. So instead of death, we are going to replace it with reclusion perpetua. Again, we have questions here now. What is the crime committed when 1 stabbed Pedro in the stomach with a knife and Pedro died? So namatay si Pedro. The answer is homicide. Huwag niyong lagyan ng murder kasi wala namang nakalagay na qualifying circumstance. Kapag walang qualifying circumstance, huwag kayong mag-assume. So ilalagay niyo lang is homicide. How about in the second example? Stabbed Pedro while sleeping and Pedro died. So etong while sleeping, this can be a qualifying circumstance of treachery. Hindi nakaput up ng defense kasi natutulog. So the possible crime committed is murder, qualified by treachery. Sa letter C, stabbed Pedro in the stomach with a knife with the intention of killing him, but Pedro did not die. So may intent to kill? Meron. Namatay ba si Pedro? Hindi. It's only attempted or frustrated homicide. How about sa letter D? Stabbed Pedro in the stomach with a knife with no intention of killing him and Pedro did not die. So walang intent to kill at hindi namatay si Pedro. Physical injury only. So that's it guys. Those are the crimes of murder, homicide, infanticide, and parricide.